So at this point, Ben, I think you're going to facilitate.
Okay. Thanks, Julie. So if you have questions on the process or what Julie just asked, let's have them.
First of all, thank you. On the map, the white lane, what is that?
Private.
Thank you.
Did everybody copy that? No. What he was asking, what the white was on the map, that would be all private. That would be non-state land.
There are some county parks in there, but again, pick up a state trust land map and it will show you those as well.
When you said the county has paid dearly for the process, what exactly did they pay for?
Specifically, I was referring to the appraisals that are expensive.
Microphone, please.
I was specifically speaking to the appraisals because that can be a very pricey process. When the original agreement was signed with the county in September of 2008, it was to move forward with an intertrust to meet these objectives and then ultimately position those lands so the county could request a reconveyance if they chose. Then a year later, we signed an interagency agreement with the county where they agreed to pay up to $291,000 to accomplish this work. So to date, we have spent $208,000, I believe, that the county has paid for, and the bulk of that is in appraisal process. It's just been a huge undertaking.
At the risk of mentioning our word, is there another cost to the county once that appraisal is completed?
The question was the cost to the county once the appraisal is completed. To process the reconveyance is staff time. The county and the state will present to the Board of Natural Resources when the county makes that request. So the bulk of the costs have been covered. It's mainly staff time to prepare and review that reconveyance request.
Is that within the 291 or?
The county sure hopes so.
That's correct.
Is there advantage to the state in doing this kind of intertrust exchange? I mean, in other words, will DNR be, will those lands be better positioned to be managed by DNR? I mean, is the state benefited by this?
Question is the state benefited by doing this intertrust? Are the lands going to be positioned for better management? And the question is absolutely. We would not have gone forward, irregardless of whether the county had offered to pay or not, if it didn't make good sense for our trusts. And again, as you look at the blocking up, if we're trying to manage land and put up some timber sales and a portion of the sale is in one trust and a portion of it's in another trust, it's some paperwork, it's a sale layout. There's different challenges to us if it's a mixture of trust. So it absolutely has to pencil out for the department. The intertrust exchange has to be as close to equal value as possible. But there's efficiencies to be gained by us blocking up.
Sir, let's assume that this goes through. And 1, 2, 5 years from now, we decide, holy smoke, what did we get into? Can we give it back?
Okay, the question is, do we get the yo-yo back? The law provides that the county must use this property for a park. And as we've looked at our internal processes, we don't have a nice little guideline that says how long do they have. So we're looking at 5 years, we make a phone call and a site visit and we say, look like a park? Looks like a park to me. No, it doesn't look like a park. If it's not, then we talk with the county, what are your plans? Are you stuck in a permitting process? What's going on? And we think that 10 years is about long enough for it not to have any activity on it to become a park. And then the state, by law, can request it to be reconveyed back.
Julie, can the county give it back?
Oh, I'm sorry. Can the county just give it back?
Put it back in county trust status. Under the RCWs, I believe that's also an alternative the county has.
So the question is, can the county just give it back? Yes, the county can give it back. DNR doesn't have to request it back. I mean, it would be a mutual agreement. Depending on what's happened to the property, it has to be returned in the same or better shape than it was when it was conveyed out.
Yeah, the gentleman up front asked about cost to the county, and I
I see an item here about lost revenue. Is that considered part of the cost of the county or in Ross County?
Okay, the question is the loss of revenue considered a cost to the county?
There is a loss to the county in terms of revenue it receives off of this of about $96,000 a year. The costs that we have, depending upon if you're talking about the reconveyance costs, that's a contract we have right now to go through that process with Department of Natural Resources and County Council to make that decision on there. And then in addition to that cost, there are other costs associated with managing any of these lands and properties, as well as the loss of the trust revenues that directly go to the county on the property. So I think if you're looking at what the trust revenues that would be generated on the county side of it, I think collectively is around $96,000. And those are round numbers simply because the final configuration hasn't been completed on the reconveyance itself. We know approximately how many acres and what it looks like.
And how did you arrive at those round numbers?
Those are based off of, if you look at Table 11 in the EIS that was prepared for the Lake Whatcom Landscape Plan, which the county had asked in 2008 for the Department of Natural Resources to reconfirm that. That is where those numbers are based on. You do have to adjust that chart because I believe since that time the amount DNR retains went from 22 to 25% on there. And then in the configuration itself, there are some lands that had been anticipated to be taken out of county forest board transfer that I believe are going to be left in.
What's going to happen to the pink lands, the lands that go to the state?
The land that stays with the state, what happens to the pink land that's still managed for K-12 construction? So we manage it for revenue, whether it's a communication site lease or timber sales, et cetera.
Any other questions?
I guess I have a question. I'm not really, is the intertrust exchange process the process of doing appraisals, the surveys, getting all of our ducks in a row, and then basically reconveyance is what the county comes in and votes on and says yay or nay, thumbs up, thumbs down, we're going for it? Or I don't really sort of understand the two-step process here.
If a county looked at some forest boards, some nice blue land, and said, we'd like that for a park, if that was the spot they wanted, they could just request reconveyance from DNR and we'd go through the process and reconvey it back to them. In this case, it's a mixture of trust. You can only reconvey that blue or state forest board land. So we have to turn it blue. So that's why the intertrust is not a normal step for a reconveyance if it was straightforward county land, but because it's a mixture of trust, we have to do the intertrust first.
And then I didn't get around to the handout, so I don't know if this is in there, but you mentioned 4,711 acres, and I've read that there's two blocks basically, one's 4,000, one's 4,700. Am I missing something on that as far as about total of 8,700 acres in the...
So the question is how many acres are in the intertrust and then the reconveyance. The round number is 8,000 acres is what the county ultimately is going to request back to use for park purposes on both sides of the lake. For the appraisal, we only needed to appraise 4,711 acres.
Julie, I didn't hear you mention it in the presentation, sorry if I missed it, but for context, and county folks can correct me, I wasn't around originally, but the county came to the state some years ago and said, you know, we'd like to have all of our 01 lands in the watershed back. And the state looked at that, and the county too, and said, wow, okay, but there's this checkerboard, if you will, of ownership. And that creates complications for both of us down the road. So the agencies agreed it would be in both agencies' interest to do this intertrust exchange to facilitate a reconveyance that would work better for both at the end of the day. And so that's the short story of why we're first doing this intertrust exchange. I think one question asked about whether it was in the state's interest to do that. In this context, it certainly is. It's probably not an exchange we would have done absent or outside of the bigger picture request for reconveyance, but in that context, it definitely makes sense to block those trust lands up for the purpose of future management, but also for the purpose of not having chopped up ownership that's tough for us to manage and tough for the county to manage as parkland. Well, that's why it's complicated, but that kind of boils it down to the simplest terms I can think of to explain kind of the whole story.
Okay, way in the back there.
Will the intertrust exchange remain this block formation even if the reconveyance doesn't go through?
Will it remain in this formation if the reconveyance request doesn't go through? Absolutely. Again, as I mentioned, it has to work for DNR and for those trusts involved, or we wouldn't be doing it. So it will go through, we'll do the intertrust, we'll block them up, change all our GIS maps, so the next printing of the state lands map will look a little different around the lake. If the reconveyance isn't requested, it stays in that blocked up formation.
Sir?
So you said that the area in pink there can be clear cut basically. How about the area in blue? Is there any rule that once that becomes parkland that the county can or cannot clear cut that area?
So the pink land will be harvested. Will the blue land be harvested? If it's not part of the request for reconveyance, it will still be part of the trust land managed for revenue.
I think the question was whether the future park ownership, county ownership, would be
Yeah. I can answer that, and yes, the county would then be putting together a forest management plan and be in control of that particular block. The intent would be to use it for park purposes, but we would imagine that we would draft a forest management plan that would go along with the properties, much like we do with some of our park areas.
Any other questions?
Could you define park? We hear park, we hear reserve. Could you just define what you guys consider legal as a park?
Well, number one, there is no definition of a park that we can find in statute. Trust me, we've looked. Particularly for those of you that have heard about the parks, AKA gun ranges, that we've been working on recently. For park purposes, we rely on the statewide comprehensive outdoor recreation plan, which is run and operated and updated every couple of years by the Recreation and Conservation Office. In that plan, they talk about the variety of recreational opportunities that the public in the state of Washington wants to have access to, which includes gun ranges, hunting, fishing, trails, all kinds of activities. When the county requests reconveyance for park purposes, they need to tell us why their request is consistent with their county parks plan as well as that statewide outdoor recreation plan.
Is another question in the back?
The question about the forest practices, and I guess I can ask you, is this going to be consistent with the Lake Whatcom management plan for timber harvest, or is there another standard that's
On the county portions?
Yes.
On the portions that the county would acquire, actually our intent would be to take a look, and it would be more stringent than what the existing landscape plan currently is.
Okay, I saw another hand back there. Okay.
The recent passage of the community forest bill in the legislature, does that make this process unnecessary? So we wouldn't have to do this intertrust exchange? I don't know if you folks are familiar with that.
You can handle that.
Question was, does the new community forest trust bill that was passed by the legislature make this obsolete? The community forest trust is intended to set up a separate kind of trust land that is not generating revenue to the extent that our current trust lands are. It can be a lighter management, it's lighter forestry. There has to be a community that's willing to support paying for at least 50% of the higher and better use for that property. So again, we're taking it out of revenue production. There has to be a community available to work on a management plan to pay for 50% of the higher and better use. It's a unique kind of trust. It's a lighter touch. The park purposes that the county's talking about, most parks are not routinely harvesting timber. And so when they talk about their forest management plan, you're talking about, do I need to take out some trees to put in a ball field or to put in a trailhead? We're not talking about a forest management plan with a revenue generating capacity. So it's a distinction between what's a park, community forest trust, lighter touch forestry, but still enough revenue to pay the costs of managing that property, versus our current trust lands that are to manage for revenue, whether there's grazing leases or calm site leases or timber sale leases. Does that answer it?
Hi, I'm Dennis Jones, last year University Watershed Master's student group. In 11/4/2004, major decisions were made at the DNR meeting regarding the forestry management plan that we worked on for Lake Whatcom. And a couple of things we found out. The number one, Austin Creek is the number one water input source. That's on this side of the lake in the area. Smith Creek is on the other side, was a major 1983 flood. And what I'd like to do is review that. There's tapes of it. Mr. Wallace or somebody that was there, and get a copy for DNR to make sure you see what happened at that meeting, including there was some evaluation of this land done at that meeting. Very short, to the point.
So you'll provide that to us after this meeting? Is that what you're saying?
I will have that provided to you.
Okay, thank you. I'll give you my card.
Yeah, I got a question. Like, regarding the land trust trade thing, it seems weird to do that before we vote on the reconveyance. Is that, because it seems like there's a major benefit to DNR in that it simplifies your guys' procedures as far as logging it and whatnot. Is that kind of normal, or if the reconveyance doesn't go through, will we still treat it as a park, or what happens if the reconveyance doesn't go through?
If the reconveyance does, he's asking the question, if the reconveyance does not go through, it'll stay in the same management scheme it is right now. The DNR will manage it for revenue, and whatever our harvest got, we look at that, manage it under our HCP and whatever other restrictions we have up there. And then there is the Lake Whatcom management plan, so we have to comply with that as well.
But it seems like you'd want to have the reconveyance already kind of figured out, because it seems kind of pointless as far as the county's concerned if they don't do the reconveyance. They spent the money on the surveying, the $300,000, and then the reconveyance going to go through this.
Mike might be able, he might be able to help me ask, but I think what it is you got to know what you're reconveying, so that was one of the pieces here. So there was, if you remember in the presentation, there's about 4,700 acres there that we had to sort out because it was all scattered. So I think now that the county has an opportunity to see what the picture is going to look like, now they can decide whether this is something they want to, proceed with.
If I can kind of say, this has been somewhat of a collaborative process as we move through, because first of all, while the reconveyance is at the request of the county, and we wouldn't request it unless we thought we were going to be able to get it approved in that with the Natural Resources Board, the intertrust exchange is entirely up to the Department of Natural Resources. So it's important that it works and it be beneficial to them, because otherwise they don't have to do that. Back in 2008, we looked at a number of configurations in terms of previous lands, and while hoping not to get too far in the reconveyance, but I can just show, the reason these blocks work for us is because this big white area that you see right here is Lake Whatcom Park and already county park ownership. Our trail runs all the way down to about that spot, and then the rest of this is owned by Department of Natural Resources. On this side, this kind of area here, this is county park property. This over here, the Sun Valley Trails and Communities area that links up with Stimson. We looked at Squires Lake, which sits right about here in the Pacific Northwest Trail, and wanting to make that link prior to even talking about this. And then the city and the county have ownership blocks sitting right over here at Lookout Mountain with trail connections and some agreements that we have right now with some of the timber companies on use of those. Additionally, another item that has come up, this is Galbraith. This is part of that area with Polygon, if the community is aware of it, up along here on this side. So there was a lot of reasons to make that block and that configuration work for county park purposes and for recreation. And then entering into this, the other thing of concern, but we can't reconvey for that, was concern for the watershed. Much of the area in blue that the county will retain is some fairly severe slopes and unstable, and probably the best thing to do is to leave it, and under a long-term forest management plan that the county would have, I would envision that would be looking at moving that forest into an older growth environment to try to stabilize those slopes and to benefit the watershed. That's another value of doing this. But the configuration that we decided upon and came back with works very well for the connectivity of not only city-county parklands, trails, but also some of the private communities and neighborhoods within the watershed as well.
Would you just restate your name and what you are?
I am Mike McFarland. I'm the County Parks and Recreation Director.
Right there.
You guys have to operate under the Lake Whatcom Management Plan, right?
For that area within that boundary, I believe.
Any area, Reconveyance or not, right? That you have to operate under our Lake Whatcom Reconveyance.
Right, if it's within that agreement area, right.
Right. So, whether he just mentioned about steep slopes, protecting steep slopes. My understanding, you can't log on steep slopes because of the Lake Whatcom landscape plan. Am I incorrect?
Paul, do you know if they can log on? Well, I mean, if there's some restrictions on the harvesting. I don't know that.
Yeah, I think it's
There must be a.
Generically speaking, people have a tendency to think that if something is identified as potentially unstable, that you can't do anything there.
I'm talking steep slopes.
Well, the problem is what's the definition of steep?
Yeah, steep slopes would be a kind of potentially unstable ground, so to speak. It doesn't necessarily mean that you can't. There's a higher level of restriction or protection in those areas. They're more difficult to operate in. They're more expensive to operate in because of the planning and engineering that might be involved.
And you're talking about our landscape plan?
Yeah, the Lake Whatcom Management Plan, yeah. And it's more restrictive than other areas in which DNR manages trust lands.
Yeah.
I don't work in the program that administers that plan, so I'm certainly not an expert. But that's my understanding of it. Yeah, it's required. There's a higher level of protection in those areas in the landscape plan than there might be elsewhere.
Yeah.
One other point of clarification about your question, sir. Because we haven't talked much about the reconveyance process tonight, it's probably not clear to a lot of people. For any reconveyance, there's kind of two, not exactly legislative, but board, if you will, approvals that are required. One is at the county level. The county has to legislatively agree to and request the land for reconveyance. The Board of Natural Resources ultimately approves whether DNR will move forward with that. And in order to get to the Board of Natural Resources, you have to have the right color land, blue land. So we can't even go there without first doing the intertrust exchange. That's why the two-step process, and that's why that comes first.
Okay, go ahead, ma'am.
Yeah, you talked extensively about state lands, state and county. My question is about private property owned in the watershed there. In two parts. Number one, has there been any private property involved in either direction on this land rearrangement? And the second part is, are there any future plans for relating to or involving private properties in the county parks program?
Well, as far as private property involved in the intergrant exchange, no, this has to deal with state trust lands. And as far as what the plans the county has, I'd have to, on private land.
I think both the city and the county continue to work on private lands development and ownership within the watershed there.
Okay, are we close to moving on to the actual hearing testimony? We got another question?
Why are we here tonight? Which is to say, my understanding is that this is purely a DNR project instigated by the county's interest. Basically for the benefit of DNR. It wouldn't have been undertaken. And once DNR is finished with this project, then maybe it can go forward. So what are we doing here tonight? DNR is going to do this, right?
Well, we have a public process we have to go through anytime we do anything, so that's one of the key reasons. And I think when we started here, we talked about this agreement. The county was looking towards trying to do the reconveyance, so then that kind of began the whole thing. But before that, they were willing to go to the reconveyance. They were looking, okay, how can we best block this up? And that's the process we're at right now. And then after we get through that piece, then the county will be in a position to decide whether or not they're going to move ahead with the reconveyance. I don't know if I captured that.
Well, I think the other important piece in the statute that allows for intertrust exchanges is we have to go before the Board of Natural Resources. So even though the county is paying for this to do all this work, we still have to present it to the Board of Natural Resources, and they have to say, yes, it makes good sense that you've done all this work. So there's that additional step to close that public process.
If there are no further questions, I'm going to turn this over to Stan Karowski, which will start the testimony.